Let's walk the talk.
702.
So the Western Cape High Court has declared the National Assembly's appointment of impeached Judge John Hlophe to the Judicial Services Commission as unlawful and invalid. The MK party had nominated its deputy president to serve on the JSC last year. The ruling follows a court challenge by the DA, which argued that Hlophe should not be allowed to serve on the body responsible for overseeing judicial appointments and discipline. Hlophe, of course, was impeached following a process that found him guilty of gross misconduct. I'm joined now on the line by the MK party spokesperson, Ndlela. Nhlamulo, good morning to you. Welcome to Radio 702. I mean, the MKP was quite emphatic coming out and rejecting this particular judgment from the Western Cape High Court.
Good morning to you, Tshidi, and good morning to the listeners. Yes, indeed. We are utterly disappointed and shocked at this outcome. As you know, we stated categorically that all processes within Parliament were followed. And let's also remember that Parliament has got its own rules. When you're a member of Parliament, you're eligible to participate in any committee. You should not be restricted in any way or form. And in this case, Dr. Hlophe was elected to participate in the JSC, at which point now we find, at a later stage, that the DA then decided to take this to court, and the courts are now overturning decisions that are being made by Parliament.
I mean, I couldn't see it going any other way. When you say you're disappointed and a little bit of shock at the outcome, I couldn't see it going any other way, even though you make an argument that for me is rooted in the clinical aspect of the law. There is the ethic conversation around this, which is what people keep raising, is that the appointment of somebody who had been found to be wanting as far as conduct is concerned, being placed in that position, raises a conflict conversation, raises conflict of sorts. Does that not carry any weight with the MKP?
Well, let's not also forget that, impeachment is a political process which was taken by a vote between the DA and the ANC, and effectively the GNU that you see. So at what point do we draw a line between politics and effectively objectivity and what would be the rule of law? In this case, as we say, the powers and privileges vested within Parliament are drawn from the Constitution. We as lawmakers make laws as that represent and should resonate with the people that voted us in, our electorate. Now, to have courts and judges that are unelected, by the way, reversing those decisions is a serious issue, because lawyers, in the form of judges, because they are advocates, are supposed to interpret the law, not even implement it.
Yeah.
And now what we're finding is that, judges and courts are making decisions at a go, and they are unelected. And let me just bring something that's interesting fact for you, Tshidi. In Mexico, as of 3 days ago, it was announced that moving forward, judges are going to be elected by the public. And this is something that we need to start looking into. Because as it is now, judges are making decisions that now no longer resonate and in actual fact infringe on the rights of the people that voted for us and the likes of a person such as Dr. Hlophe to participate in there. So for courts now to go and reverse decisions that lawmakers make and start overreaching in processes within Parliament becomes a serious problem. Because what that would mean now is that it's going to lead us to what is becoming judicial sovereignty.
I actually want to ask about the next step for the MKP, because if you go to another court, the likelihood from where I'm sitting is that this particular judgment will be maintained. It will remain exactly this. So what would be the remedy then to this issue? Do you accept it and then say, it's unfair, we need to focus on changing how the courts function, we need to work on that, or do you continue and go to a higher court?
Well, we are law-abiding citizens and a law-abiding party. So first and foremost, we're going to take this to the highest courts, right up to the Constitutional Court. So we're not going to take this lying down. We also have been, as we stated from day one, as Umkhonto Caesar, as part of our party posture, that we want Parliament sovereignty to ensure that the will of the people in terms of decisions that are taken in Parliament resonate and are representative of the people's will. And that we should actually do away with this constitutional that in its current form. And yes, where there's areas where we believe that the Constitution indeed, for instance, the Bill of Rights, ought to be brought into mainstream of the framework that we're looking at it from a parliamentary sovereignty perspective, then that should be the case. But we can't have a situation where people who are voting and who want certain policies and certain decisions implemented only for the courts in the form of unelected judges to reverse them.
Before I let you go, I'm just wondering, the constitutional amendment, constitutional review period, the deadline for public input just passed. We do know that Action SA has raised a particular matter around immigration. You raised the issue of how we are at threat of having a judicial sovereignty. Did the MK make contributions? Did you make submissions about what you want to see changed as far as some of our approaches, even to issues like this?
Absolutely. And as far as it even pertains to the issue of land, that we should review Section 25.
You've made those submissions already?
That's including the correct, yes, we have made those. It's quite comprehensive, and it's reflective of our policies and our party policy in terms of the people's mandate.
All right, thank you, Nhlamulo. I'm going to leave it at that. Thank you so much for your time. That's Nhlamulo Ndlela, who's the spokesperson of the Umkhonto weSizwe Party, rejecting the outcome from the Western Cape High Court, saying that they'll go to the highest court in the land to fight this, saying that the impeachment of Dr. John Hlophe, and I think it is a legitimate argument to make, is in and of itself a political process, saying that it was done by GNU partners. I'm going to take a quick break, but when we come back, we'll hear from the DA spokesperson, Willie Aucamp. The DA is the party that took this matter to court in the first place. Willie joins me now. Willie Aucamp is the DA spokesperson. They took the matter to court. Willie, good morning and welcome to Radio 702. You've kind of seen the outcomes of the Western Cape High Court as a victory for the rule of law and the Constitution, but the MKP, in making an argument, does say that the role of Parliament is thus undermined. I want you to first weigh in on that. I mean, they say that the threat is of a judiciary sovereignty as opposed to our constitutional sovereignty, which is what we are at the moment.
Good morning, Tshidi. Tshidi, if you look at Section 1654 of the Constitution, it is very clear that Parliament has got a responsibility to promote the impartiality and the objectivity of courts. I can quickly read it to you to just give the listeners an idea of what I'm saying here. 1654 says organs of state, in other words, it includes Parliament, through legislative and other measures, must assist and protect the courts to ensure the independence, impartiality, dignity, accessibility, and effectiveness of the courts. So if you look at that section, it is clear that Parliament has a duty to protect the courts. And by electing somebody to the Judicial Services Commission that has been impeached, that has been declared unfit to be a judge, surely cannot serve on a committee that must appoint judges and also have disciplinary hearings on judges. It is the same committee that proposed that he must be impeached. So it is definitely not in the interest of justice to have a person with the tainted history like John Hlophe serving on that Judicial Services Commission.
I think the conflict definitely, without question, does arise. And that's a question that I was also asking him with regards to that particular role. Willie, they are saying that they'll fight this. They'll continue to fight this all the way to the highest courts in the land. I often find that instead of using the courts, there should be room, at least I just struggle to find it in our political space, room for conversations around what ought to happen. I don't know if that's something that is a possibility within opposition, to go, here's the situation. There is a conflict around Dr. Hlophe that arises. There's no question. You do have an obligation to give them a position, to give somebody a seat from the MKP, because that is what is guaranteed. They are in Parliament. They were voted for. So all of that is guaranteed. There's no room for conversations to remedy these things through discussions, the whips when they meet to find a way forward. I just find it odd also that we are in this weird stage where every resolution, every issue is resolved via the courts.
Yeah, it's very clear that the MK party will not sit down to negotiate this, and they've made it very clear. When Parliament voted on this last year, we made it very clear from the DA side that we will not accept this and that they can put forward another name. They were not willing to do that. We must also look at what the Constitution says. The MK party is not necessarily entitled to a member there. It says that the Parliament must adjudicate 6 people 3 out of government and 3 out of the opposition. Now, the opposition is not only MK, they are other parties as well. So they are not necessarily entitled to that, but we said to them at that stage, bring another name forward, a name of a person that has not been impeached, that has not been declared as unfit to be a judge. You cannot have people like that appointing judges. We must protect our judiciary. We must remember, Tshidi, that our government consists of 3 legs. We've got the executive power, which are the ministers and the president. We've got the legislative power that are parliament. And then we've got the judicial power that are the courts. And that is a very important leg of our government, and we must protect the independency thereof. We've also had it that judges said that or potential judges, that they will be reluctant to appear in front of the Judicial Services Commission if somebody with the character of Mr. John Hlophe is sitting on that commission. So this is really a win for the independence of the judiciary, and the Democratic Alliance, with the people that assisted us in this court case, are very glad that we've received this judgment, and we are quite sure that they will not succeed on appeal on this.
I'm pretty sure you'll continue to fight it also, just like the MKP, all the way to the highest court in the land. Are there any concerns about the impact on the idea of confidence as well when all of this is unfolding, in terms of how the public perceives all of you as political parties and how you wade and manage through issues like this? Because for me, this is an ethics conversation as well.
Absolutely. And we are taking this on not only on the words of the Constitution, but obviously in the background on the ethics of this. And I believe that South Africans value our Constitution. We've got a very good Constitution that is the highest law of our land, and we've got to protect it with all that we've got. So when the Democratic Alliance are taking issues to court to test the constitutionality thereof, we are firstly making use of another branch of government, which is the judicial arm. But we are showing people out there that we will fight as a Democratic Alliance to uphold the Constitution. And if we lose our Constitution, like MK want us to, we will be set back as a country for ages. So the Democratic Alliance don't see this as fighting. We see this as using the tools at our availability to make sure that we uphold the Constitution and fight for everybody's right to live in a constitutional democracy.
All right, thank you so much. I'm going to leave it at that. That's Willie Aucamp, who's the DA national spokesperson, who spoke to Willie Aucamp, as well as Nhlamulo Ndlela from the MKP. Holding on to the line is Mbekezeli Benjamin. I'm going to bring him in just after this voice note.
Good morning, Tshidi. Thanks for all the coverage on the John Hlophe matter. I agree with your previous caller. Nobody voted for John Hlophe. They voted for MKP, and those who were well informed enough to check the list of names that were sent to the IEC of those who would be MPs when MKP won its seats, that list did not include John Hlophe. He was added later. He wasn't even on the list that MKP said to the country, these will be your MPs.
All right, thank you so much.
So really, he's very unelected. Furthermore, our judges are appointed, but appointed by the Judicial Services Commission, which includes representatives of Parliament. If Parliament wants to block the appointment of a judge, they're able to do so through their representatives. Thank you. It's David.
All right, thank you so much for that. I do want to give Mbekezeli Benjamin a chance to speak, but Nhlamulo was listening to Willie Aucamp and he wants to give a response. Nhlamulo, please, let's keep it brief so I can give Mbekezeli a chance.
No, thank you for that. Look, here, let's start with the following. Powers and privileges of Parliament are drawn from the Constitution. Those rules allowed for Dr. Hlophe to participate in that. But we are aware and we know that, don't forget, Dr. Hlophe wrote a very damning report about the Western Cape High Court itself, where there were a lot of shenanigans there pertaining to certain cases, and more so racism that reverberated through all those courts. So it is clear that the last thing they would ever wanted is a person with the insights, 25 to 30 years of experience like Dr. Hlophe, to preside over those interviews. But let's also not mislead South Africans. Dr. Hlophe will be presiding over interviews. He doesn't appoint. Instead, it is the president that appoints. So where would the fit there be if South Africans can have a person such as Dr. Hlophe, who's got the skills, the qualifications to preside, and more so the experience and the insight of how courts and how judges ought to be presiding over the judicial system? So, you know, for there to now create and impressions of Dr. Hlophe off the back of a political process of impeachment. Remember, that was a political decision that was taken. That's what impeachment. That's what led to the impeachment. The GNU partners are the ones that impeached Dr. Hlophe.
Nhlamulo, but the question at hand is about ethics, and I feel like you're not going there, but I don't have the time. I want to give Mbekezeli Benjamin a chance to also weigh in on the argument you've made, so I'm going to let you go. Thank you so much. That's Nhlamulo Ndlela from the MKP. Mbekezeli Benjamin, who's a research and advocacy officer at Judges Matter, I think listened to a little bit of that. Mbekezeli, good morning. Welcome to Radio 702. So Nhlamulo explaining what's happened to Dr. Hlophe. For me, it's about the GNU, it's about the racism in the Western Cape High Court. It's about anything but the question of ethics, the question of conflict that should arise about having somebody who had been found wanting by the JSC serving in that particular body.
Good morning, Tshidi, and good morning to the listeners. You're quite right. That is exactly what the judgment of the Western Cape High Court emphasizes, is that not only the fact of the impeachment is not the biggest issue. The biggest issue is why was there an impeachment, the impeachment was based on a finding of gross misconduct. And that gross misconduct was in the nature of Dr. Hlophe interfering with the Constitutional Court in violation of Section 165 of the Constitution. And so the Western Cape High Court in its judgment says that if you look at that fact, and you also look at the fact of what happened after Dr. Hlophe was impeached as a judge, his conduct towards the judiciary, the statements that both himself and the MKP have made in various guises in response to court judgments, that is a factor that should have been considered by the National Assembly when it was taking a decision to designate him as a member of the Judicial Service Commission. Because the Western Cape High Court says, if you look at the power given to the National Assembly in Section 178, subsection 1H, and read it against Section 165, subsection 4 of the Constitution, those two sections make it very clear that the National Assembly has a constitutional responsibility to make sure that when it designates people to the JSC, those people are able to uphold the integrity, independence, and credibility of the judiciary. And the court said Dr. Hlophe is not one of those people.
That is a question that I think we didn't delve into very much. Because I'm going to try and keep you on for a little bit. It's time for me to go to headlines, but I do want to speak to you about a few more things. There are questions coming up from the listeners, even on Twitter, that I'd like you to indulge for us. And there's an issue that Nhlamulo Ndlela raised about judges being appointed directly by the public, speaking about a Mexican example. And I want you to weigh in on that feasibility. It's something that another listener on Twitter asked about. How would this actually work? But I want you to think about all of that and whether or not what's happened undermines the role and the work of Parliament. So we'll answer those questions for you after the headlines. But 10:34, Tshidi Madia in for Clement Manyatela. We are discussing that High Court judgment that found Dr. John Hlophe's appointment to the JSC as unconstitutional and invalid. We are joined on the line by Mbekezeli Benjamin, a research and advocacy officer at Judges Matter, who's helping us understand a few aspects of the particular judgment. I just want him to respond to some of your questions. And Mbekezeli, thank you so much for sticking around. So some of the questions that have come through, at least on Twitter for now, Lisedi Mbona says, is it even democracy when the court can nullify a decision by Parliament? Doesn't this strip Parliament of its sovereignty? The balance and checks arguments, it's a valid one. However, how do you ensure Parliament's sovereignty reigns supreme? That's the question, and that's an argument that the MKP is making. That's, as they say, we are under the threat of a judicial sovereignty. How would you weigh in on that one?
So, under apartheid, South Africa did have parliamentary sovereignty. So, courts were not allowed to question decisions by Parliament, and that's partly why apartheid lasted for so long. So, in 1994, we rewrote the Constitution to say that there must be a balance. There are certain decisions that are at the heart of parliamentary power, and courts are not allowed to interfere with those. And then there are those that are more constitutional decisions that affect not just Parliament but other arms of state, such as, for example, the designation of a member of the Judicial Service Commission. And in those decisions, the courts may scrutinize how Parliament takes the decision. So the important thing is not why Parliament is taking the decision, but how. So in this case, the Western Cape High Court emphasized that yes, when you look at when you look at how Parliament selects people to be on the JSC, the first part is a political process, which is a nomination. Political parties are free to nominate anyone, and the courts may not question that aspect. But there's a second aspect where the National Assembly, as a body, as a collective, they must then designate from amongst themselves those people who will align with Section 165 of the Constitution. And because that is a constitutional power, the courts have a duty to make sure that it aligns with the Constitution. In this case, it did not align with the Constitution and it was declared unconstitutional. In future cases, it might be different. We don't know. But the way that our system works, the courts are basically the referees to say this is where you can play, and once you go over this line, it's an offside. This is essentially what happened in this case.
And just very briefly, your last take on the suggestion that Ndlela makes, says in Mexico the public gets to elect judges directly, saying that this is what we want. Mkonza at ZA is asking, are we going to have an election every 3 months? Your views on that one?
Well, elections for judges don't work. The Mexican example is one that came out last year by the new president, Claudia Sheinbaum. She borrowed it from the United States. In fact, in the United States, it's so broken in that 2 months ago, Elon Musk spent $90 million to try and get a judge elected on the Wisconsin Supreme Court, even though that judge was someone who was extremely unpopular, but Elon Musk wanted him elected because he was part of the MAGA movement. So the South African example is actually the gold standard when you look at judicial appointments processes around the world. It balances both the interests of members of parliament. You know, our JSC, half of it is made up of members of parliament, but we also have the other half made up of judges, lawyers. And so it's an inclusive process that is unique in anywhere in the world. So the directly electing judges actually is not good because you have a potential of billionaires buying their own judges like we saw in the United States with Elon Musk.
Thank you so much, Mbekezeli. I'm going to leave it at that. Mbekezeli Benjamin is a research and advocacy officer at Judges Matter. There's been a lot
Hanging out with Clement
on 702.
Let's walk the talk.